Well, the Commonwealth has now filed a response to Karen Reed's motion to dismiss based on double jeopardy. And maybe you've heard some of the reports about this. Maybe you've even had another channel that's actually read the motion to you, but that's not what we do, or we don't just read the motion. We actually do a deep dive into the case law that's controlling over this issue. And we explain it all, and we break it down so that you are going to be in the best position, literally the best position, because I did all the hard work. I spent the time reading these cases, which are very important to actually read the cases, as we will see as we go through this video. So if you're just relying on what the defense puts in their brief and what the Commonwealth puts in their brief, that's not a great way to go about this. You actually have to pull the cases, read the cases, and then you'll see which side maybe is going to win this motion or not. So let's jump into it. As you'll recall, the defense filed a motion to dismiss, and we did a video on this, by the way. We did a full video on breaking down the defendant's motion to dismiss. But let's just quickly go over again what their main arguments were. They had a few different arguments. Number one, they wanted to argue that really double jeopardy should attach. Why? Because all 12 jurors agree. They all agree with us now. I mean, they didn't get all 12, but they got few to say that they all agree. We'll see about that. But let's just assume that now we've got all 12 jurors in our living room. They've all come to the defense attorney's house. Let's just play this out. And they've all said that really the voting was on count 1, 12-0, not guilty. And count 3, 12-0, not guilty. Therefore, that is akin to a not guilty. That's an acquittal. And therefore, double jeopardy should attach on count 1 and count 3. And let's just bring them back to court. They'll come back to court. They'll all agree and acknowledge that, yes, that was what the voting was, 12-0, count 1, not guilty, count 3, not guilty. And therefore, the Commonwealth can only retry count 2. And I explained in the last video that that argument is going nowhere in a hurry. It's just not a great argument. Once the jury deliberations are over, we don't bring the jury back to say, oh, really, now that you've coming out after the jury deliberations and telling us what you really felt or what the voting really was, we're not going to start bringing you back. It doesn't happen. The only time that you can maybe bring the jury back is if the jury reports that there was some racial or ethnic bias that got injected into the jury deliberations, and that's why some of them voted a certain way, or if there's jury tampering or something like that. But just because the jury was confused about a jury instructions or a verdict form, we're not going to bring them back. And just to make the point clear, the Commonwealth does say in their response, they bring some case law that says that a verdict must only be reported in open court. The only verdict which can be received and regarded as a complete and valid verdict of a jury upon which a judgment can be rendered is an open and public verdict given in and assented to in open court as the unanimous act of the jury and affirmed and entered of record in the presence and under the sanction of the court. So they quote a number of cases which basically says, but it's common sense. It's just not going to happen. This argument is not going to work. So in terms of the jury all coming out after the trial and saying, really, it was 12-0, count 1 and count 3, that's going nowhere in a hurry. But what I thought was more compelling and more meritorious argument was the second part of the motion to dismiss. The second part of the motion to dismiss was the following. Okay, let's say we don't have an acquittal. Let's say we don't have a 12-0, not guilty on count 1 and count 3, and we can't bring the jury back. But if the mistrial was declared and it was inappropriate for the judge to declare a mistrial in the way that she did, then also double jeopardy could attach. So how do we go about analyzing whether a mistrial is appropriate or not? So the case law says the following, that if the defendant requested a mistrial, then that automatically the mistrial is going to be appropriate, which means that double jeopardy will not attach. If the defense requests a mistrial, then that's like a regular mistrial and the prosecution can bring the case again. Now, let's ask ourselves, let's stop. Did the defense ever request a mistrial in this case? And the answer very clearly is no. They never requested a mistrial. So now some people are now jumping off their couches and off their beds and saying, what are you talking about? The defense requested a Tui Rodriguez charge, and that's the same thing as requesting a mistrial. Well, is it the same thing as requesting a mistrial? Why don't you look at the instructions of the Tui Rodriguez charge and tell me that that's actually asking for a mistrial? It's not. All the defense is asking for is for the Tui Rodriguez charge to be read. That doesn't mean that they're asking for a mistrial. So calm down. Let's sit back down on the couch. And just by them requesting a Tui Rodriguez charge does not mean that they are requesting a mistrial. All right, now let's move on to the next part. The next part is, well, even if the defense did not request a mistrial, but if they consented to a mistrial, then that will also work, that double jeopardy will not attach, and it will be a proper mistrial. Now, you can ask yourselves, well, did the defense consent to a mistrial in this case? Well, did the judge ever ask them, Mr. Jackson, do you agree? Do you consent to me declaring a mistrial? Well, she never did that. So maybe you're going to argue that that's not consent. But we know as attorneys that if you don't like something going on in the court, what should you do? You should object. Well, was there any objection here by Alan Jackson or Yannetti? There was certainly, or Elizabeth Little. No, there was no objection here. Well, maybe the fact that the defense did not object, that means that they consented. And if they consented, then this whole motion can be thrown out the window into the shredder. There's nothing to talk about. That means that they consented. So that's the question. That's a very important question that we need to answer. By the fact that they did not object, does that mean that they consented? And the defense quoted a case called Commonwealth versus Edwards. Commonwealth versus Edwards, they represented in their papers that opinion holds that you do not need to object. And the fact that you didn't object does not mean that you consented. That's what the defense represented in their papers. Now, what should we do? Should we just take this sitting down and assume that whatever they're saying is true? No, let's actually look up the case. Let's look up the case of Commonwealth versus Edwards and see whether that is actually the holding in that case. So I did it. Don't worry. I did the hard work for you. So I pulled up this case, and this is what that case was about. The case was about that there was a certain document that was not turned over to the defense, and that document was really, really incriminating. It was an incriminating document. And if the prosecution would not be able to get that document in, most likely the defendant was going to get acquitted. So they didn't turn that document over, and therefore when it came time for trial to admit that document, the defense objected and said, well, no, we're objecting that document was never turned over to us. This is a violation, discovery violation, and we object that document should not come in. Then they had a conference with the judge, and the judge says, well, maybe we should declare a mistrial or something like that. And the defense attorney said, no, I don't want a mistrial because I'm very happy with this jury. I'm very happy with this, them getting this case without that paper, because if they get this case without that paper, my client's going to walk free. And therefore there's going to be a verdict of not guilty. And then that's clearly there's going to be double jeopardy implications there. So the defense attorney in that case did not want anything to do with the mistrial, did not want anything to do with the case being dismissed. Nevertheless, in that case, the judge, sua sponte, on his own, decided we are going to dismiss this case with prejudice. And he dismissed the case with prejudice. Now, when he dismissed the case with prejudice, the defendant didn't object. Okay, so the defendant did not object in that case, and it was dismissed with prejudice. Now, the Commonwealth appealed that ruling of the judge that he dismissed the case with prejudice. And what was interesting is that in Commonwealth versus Edwards, in this opinion, they reversed that judge. They said that was an abuse of discretion. It was an abuse of discretion to dismiss this case with prejudice. And therefore, that dismissal is vacated. Well, now, hold on a second. Now we're stuck. Hold on a second. Now, what is this considered? The case was just thrown out. It wasn't appropriate for it to be dismissed with prejudice. The prejudice means that you can't bring the case again. So now, and the defendant never objected. So does that mean that this is like a mistrial that there was consent to, and therefore the prosecution can bring the case again? Well, the Commonwealth wanted to bring this case again. So this is what the court held in that case. Listen to this, because this, it seems, is actually completely contrary to how the defense represents this case. So ready? Here it goes. Consent to a mistrial also may be implied where a defendant had the opportunity to object and failed to do so. So right there, black and white, it says very clearly that where a defendant fails to object, then consent can be implied. And again, they quote another case where the defendant sits silently by. This is Commonwealth versus Edwards quoting this case, where the defendant sits silently by and does not object to the declaration of a mistrial, even though he has a fair opportunity to do so. A court may presume his consent. So when you're reading this, you can hit the back of your chair and say, how does the defense saying that this case stands for the proposition that you don't need to object, and even if you don't object, that does not equal consent. It's literally the opposite of that. It says black and white that if you don't object, that is consent. You consented. So, what's going on in the case? So this is how the case continues. Turning to whether the defendant impliedly consented to a mistrial, the defendant argues that where a trial judge sua sponte orders a dismissal with prejudice, a reviewing court should not infer consent from a lack of explicit objection. In this case, you have to be very careful with the terms that you use. Okay, that's important. When you're doing some research, you got to see what terms they're using. Don't just conflate all the terms together. What did the judge do here? The judge dismissed the case with prejudice. He didn't order a mistrial. He dismissed it with prejudice. There's a very big difference between ordering a mistrial and dismissing it with prejudice. And here the court dismissed it with prejudice. So the defendant argues, the fact that I didn't object to him dismissing the case with prejudice shouldn't hurt me now that they're going to try the case again. He contends that a defendant should not be required to object in order to preclude a mistrial. And with this question, there was conflicting authority. The court, the opinion goes through some different authority, one way or the other. And therefore, this is how they conclude. We therefore must decide whether when a judge instigates a dismissal, the defendant must object in order to avoid a later determination that he consented to a mistrial. We conclude that a defendant has no such obligation. And this is a very important sentence, maybe the most important sentence of this entire opinion. Here it goes. When a trial ends in a dismissal, not to be confused with a mistrial, when a trial ends in a dismissal, there is no declaration of a mistrial to which a defendant can object. So in this case, where the judge sua sponte on his own decided to dismiss the case with prejudice and the defendant didn't object, you can't say, well, he should have objected because that's the same thing as needing to object to a mistrial. No, because there was no mistrial in that case. It was a dismissal with prejudice. And therefore, it would seem from this case, now the defense quotes this case as saying, and therefore a defense does not need to object. Is that by a mistrial? Is that the way to understand this case? Very clearly not. The way to understand this case is that just the opposite, that when there's a mistrial, then the defendant does need to object. And if he doesn't, then it's implied that he consented. So this case, which the defense quotes, actually stands for the exact opposite proposition. This is not going to help the defense. Okay, and if the judge asks them about this and pushes on this, they may be in a little bit of a hard position to defend themselves. All right. The state, though, continues. Okay, now, because there could be technically another argument here that you can make on the defense's side. And that is that there still has to be an opportunity to object. And they can maybe make the argument that they did not even have that opportunity. Well, let's take it step by step. Now, the state also quotes a number of cases. Now, for some reason, if I was the state, the Commonwealth, I would quote this exact case, Commonwealth versus Edwards, and say this exact case that the defense quotes to stand for the proposition that even by not objecting, that is not consenting, is completely opposite with the holding. That's what I would do. But it seems to me that the Commonwealth did not look up this case. And they should have, because this would be a really great argument to say that the exact case that the defense is relying on actually supports my position. All right. But they quote some other cases. Now listen to these other cases. These are also good cases. Commonwealth versus Fetsaya. This is Phettsaya, 40 Mass Court 293, 1996. What happened in this case was actually interesting. It was the defense attorney's first trial. Okay, this is defense attorney, must be a young defense attorney, his first trial. Okay, and then after the defense rested, the judge told the defense attorney in front of his client, he said to him that he's very troubled by his performance. And he doesn't feel that this defendant had effective assistance of counsel, meaning his Sixth Amendment constitutional guarantee was violated. So the judge was kind of like just talking on the record. I don't know what to do with this because you're such an ineffective attorney that I don't think the defendant had his constitutional rights upheld. And therefore, I don't know what to do. So the prosecutor suggested, well, maybe you should order declare a mistrial, and we'll do it again and we'll get some other counsel here. And the judge then said, if I order a mistrial, this is just like in conversation. So he's like, if I do, then I'm going to assess $1,500 of sanctions. This is in 1996. I'm going to assess $1,500 of sanctions against the defense attorney. The defense attorney responded, I understand. He was very cordial, very respectful. He said, I understand. Then the judge did not ask the defense counsel to comment about what he's going to be doing. And the judge said, okay, I'm going to order a mistrial. I'm going to declare this a mistrial. Then what happened is that this defendant went and hired a new attorney. This new attorney saw what was going on, and he filed a motion for dismissal because the mistrial was not consented to, and therefore double jeopardy should attach. So that was going on in this case. And this is what the court said. Again, consent to a mistrial may be inferred from silence, where a defendant had the opportunity to object and failed to do so. Here we go. So the same exact idea. If you don't object, then that equals consent. Now listen to what they say here. It's very cute. We hold that in the circumstances presented here, the lack of objection from defense counsel cannot be construed as consent to the declaration of a mistrial. So hold the phones. What's going on over here? You just said that if you're quiet and you don't object, and here was very clear. The judge was talking about, should we order a mistrial? The prosecutor said, maybe we should order a mistrial. And the defense is sitting there. Why didn't the defense object? The fact that he didn't object, that should be consent. But this is what the case holds. The lack of an objection from the defense counsel cannot be construed as consent to the declaration of a mistrial. Although not intended by the trial judge, the judge's statements to defense counsel that he was incompetent and ineffective, and the judge's action of assessing defense counsel $1,500 in costs were undoubtedly so intimidating to defense counsel, who was trying his first jury case, as to foreclose any objection from defense counsel to the declaration of a mistrial. So here, the defense attorney, the court is holding that the defense attorney here, it's his first trial. He's being screamed at by a judge. He's being assessed $1,500 in costs. He's being called ineffective. He's embarrassed in front of his client. Now you want him to object to the mistrial? So the court is saying here, by the fact that he didn't object, is not consent. Hear this? As for the defendant, after hearing the trial judge state that his lawyer is incompetent and ineffective, so then, well, what about the defendant? Maybe the defendant shouldn't have objected. So he said, well, as for the defendant, after hearing the trial judge state that his lawyer is incompetent and ineffective, it cannot be expected that he would object to the declaration of a mistrial. So you can't expect the defendant to object. And now listen to this. This is a great way that this opinion ends. The assessment of $1,500 in costs against the defense counsel deserves comment, even though the judge later waived the payment. So the judge later felt bad, and he said, you know what? You don't have to pay the $1,500. But the court still wants to talk about that, the fact that the judge did that. We are not aware of any authority that permits a judge to assess costs in these circumstances. Defense counsel was not contemptuous in his speech to the court. In fact, he was obsequious, almost to a fault. The record is barren of the judge's reasons for assessing costs against defense counsel, and we fail to see why they were assessed in the first place. So they really sticking up for this attorney, this young attorney who tried his first jury trial, was screamed at by a judge, assessed costs. So here you got the reviewing court who's sticking up for that attorney. And also in that opinion, by the way, they say that he was effective. He was not considered ineffective. So they really wanted to encourage this young attorney. And that's how that case ends. Anyway, a very interesting case. You want to look it up. It's the Commonwealth versus Fetseya. All right. Well, what do you see from that case? You see from that case that unless there's like a first jury trial where the judge is screaming at somebody and then he doesn't object, that's the only time that will construe his failure to object as still not consenting. Otherwise, if you didn't object, then that is consent. And this is certainly not Alan Jackson's first trial, and it's not David Yanetti's first trial. So far, this is what the state, again, the Commonwealth is quoting to show that the fact that they didn't object it means that they consented to the mistrial. All right, let's continue. Then there's another case, Daniels versus Commonwealth. This is also a case quoted by the Commonwealth. The jury answered. So this is something that the jury answered in one of their notes to the judge. I'm just quoting part of the case. Again, we're dealing with a hung jury. In all these cases, they're dealing with a hung jury. And this is what the jury wrote back. Further deliberation will not yield a unanimous verdict on any indictments. When asked by the judge what he thought about the jury's response, defense counsel said, I think they're at an impasse at this time. When asked whether he had any objection to a mistrial, counsel said he had none. So in that case, there's a hung jury. The jury sent out a note saying further deliberations will not yield a unanimous verdict on any indictments. The judge asked the defense attorney, what should you do? What should we do? He said, I think they're at an impasse at this time. And then the judge said, do you have any objection if I order a mistrial? The judge and the defense attorney said no. The next day, the judge declared a mistrial and discharged the jury. Okay, so this case is very clear that the defense attorney was given every opportunity to object, and he did not object. So again, you see the fact that he did not object equals consent. However, in this specific case, Daniels versus Commonwealth, the judge specifically asked the defense attorney, do you have any objection? And he said no. So very clear that he consented. All right, moving on to the next case that the Commonwealth quotes. This is called Pellegrin versus Commonwealth. Here, again, evidence was not turned over to the defense, and the judge on his own declared a mistrial, and the defense didn't object. And again, they quote, in this case, consent to a mistrial may be inferred from silence where defendant had the opportunity to object and failed to do so. Here we go. And here we go. Here he says, Pellegrin plainly had the opportunity to object. The mistrial was declared after a voir dire and colloquy after the jury were cleared from the courtroom. So again, there was discussion about what to do. And once there was discussion about what to do, the defense didn't object, but there was discussions about what we should do. And then the court said, okay, I'm going to order a mistrial. And there was no objection. So that is going to be considered consent. Despite having an adequate opportunity to object to the mistrial, defense counsel remained silent, implying that Pellegrin, in fact, had no objection. We also see no reason to disturb the judge's finding that defense counsel specifically assented. In these circumstances, it was proper to infer from defense counsel's conduct that Pellegrin consented to the mistrial. So again, another case where the defense didn't object, and that was considered consent. So all these cases are really working out in favor of the Commonwealth here to say that if Alan Jackson didn't object, or David Yannetti, then that is the same as consenting. And as we said before, even the case that the defense quoted is really in favor of the Commonwealth, in my opinion. All right. So the only argument that I see, potentially that the defense can argue back in a reply, is the fact that in all these cases, there was an opportunity for the defense to object. I mean, the judge either had a conversation with them, or as some of the courts say that some of the opinions read that there was an opportunity to object and they didn't object. Here, the defense is going to probably make the argument that they didn't even have the opportunity to object. If the court would have said, I'm thinking about ordering a mistrial or declaring a mistrial, then, okay, I mean, maybe we would have had the opportunity to object. But in this case, as soon as she was done reading the note, she said, I'm declaring a mistrial. So there was really no opportunity from the time that she was contemplating or declaring a mistrial to the time when they can possibly object. Because before they knew it, she said, I'm declaring a mistrial. You all go back to the jury room. All right. So now here's another case which has to do with the Tui Rodriguez charge. And it's a very interesting case. Because listen what happened here. Again, we have a deliberating jury. They're hung. And this is what the opinion says. At about 2 p.m. on Monday, the jury submitted a third note. This is also, again, of course, quoted in the Commonwealth's papers. It's called Ray versus Commonwealth. At about 2 p.m. on Monday, the jury submitted a third note declaring that even after very careful consideration of all the evidence presented, they were hopelessly deadlocked. After reviewing this note, listen to this. After reviewing this note, the judge indicated that he was inclined to declare a mistrial. So again, this is out of the presence of the jury. They got this note. The judge tells the attorneys, okay, I'm inclined to declare a mistrial. Both the prosecutor and the defense counsel requested that the court give the jury a Tui-Rodriguez instruction. So they asked, let's give a Tui-Rodriguez instruction. Don't just declare a mistrial yet. You didn't even give the Tui-Rodriguez instruction. The judge declined to give this instruction and declared a mistrial over the defendant's objection. So he asked, again, the defense attorney objected to the mistrial and said, I want you to read the Tui-Rodriguez instruction. And the court said, no, I'm declaring a mistrial. Now, listen to this. Defense counsel's affidavit states that both parties requested that the judge give a Tui-Rodriguez instruction, permitting the inference that both parties were provided an opportunity to be heard on possible alternatives to a mistrial. So hold on a second. If the judge is having this conversation with you, that means, number one, obviously you have the opportunity to object. But number two, remember, there is another prong here. And the other prong is that were there other alternatives that were available besides declaring a mistrial? And in this case, they both said the Tui-Rodriguez charge. Let's give the jury the Tui-Rodriguez. So this was a possible alternative. As the defendant emphasizes, however, the judge indicated that he was inclined to declare a mistrial prior to hearing from the parties. While it would have been preferable for the judge to refrain from expressing an opinion on the need for a mistrial until he heard from counsel, the fact that the judge indicated an inclination, meaning he didn't say, I'm sold on it. He said, I'm inclined. Now, is it just semantics? And really that's how he's saying it, even though that's what he's decided in his mind to do. That's not for our discussion. The point is that since the judge said, I'm inclined, and we have to take his words at face value, and an inclination does not mean that he's completely sold on that action. So that means that there's opportunity to suggest alternatives to the mistrial. So indicating an inclination to declare a mistrial does not support an inference that the judge had closed his mind to other alternatives, or that the subsequent hearing was a mere formality. And therefore, since you're right, the defense objected, but the judge did technically consider giving a Tui-Rodriguez charge and decided not to. So everything is met in this case, and therefore they were able to bring the charges again. Double jeopardy does not attach. All right. So that is in with respect to the objection part. So again, it's really going to come down to the case law is clear. It is clear that the failure to object does equal consent. Okay, but the fact that the defense mentioned in its motion and its brief and quoted a case out of context, that it does not mean that, it's just not the case. By failing to object, you are consenting. The only argument that I see here that the defense can possibly make is the fact that they're going to argue that we did not have the opportunity to object. That's what they're going to argue, even though we should have objected, but we just simply weren't given the opportunity to object. And that's the only reason why we didn't object. And therefore, you should not construe our failure to object as consenting. So now let's move on to the next part. Okay, so now that we're done with, there was no request by the defense, but there's certainly a strong argument to be made that there was consent here. Well, let's just for devil's advocate, play the card that there was no consent here. And the defense will be able to argue that there was no consent. We didn't have the opportunity to object. And therefore, you're right that in a normal situation, if this was a regular situation where the judge would have called us in and asked for our opinions and we didn't object, you're right, that would have been consent. But in this specific situation, since the judge didn't even read us the note, read the note, right away declared a mistrial, didn't even give us the opportunity to object, so therefore it's not consent. So let's just play this card because we have to completely go through all of the different options here. So even if, as we explained, there's no request and there's no consent, still, if the judge feels that there's manifest necessity, so then that will also be a good enough basis to declare a mistrial, and double jeopardy will not attach. So here we had a very interesting case that the Commonwealth quotes. It's called Fuentes versus Commonwealth. Here again, we had both sides were, the jury was hung, and the jury returned to the courtroom along with the prosecutor and defense counsel. Defense counsel at this point had not been informed of the contents of the note. So listen to this case because it's almost exactly the same exact scenario that happened in Karen Reed's case. Fuentes versus Commonwealth, 863 Northeast 2nd, 43, 2007. Okay, so again, the jury's deadlocked. They come back into the courtroom. Defense counsel at this point had not been informed of the contents of the note. All the defense counsel knew was that there was a note that was given to the judge, and they called the jury in. Sounds very similar to this case. Now listen what happened. Addressing the jury, the judge stated that she had received the note, which stated that the jury could not reach a unanimous verdict as to either indictment. The judge thereupon stated that she declared a hung jury and a mistrial. She did not consider any alternatives to declaring a mistrial, and she did not give defense counsel an opportunity to be heard before doing so. Literally the exact same situation. This is Karen Reed. This is Fuentes versus Commonwealth all over again. After the jury was dismissed, now listen to this. After the jury were dismissed, defense counsel lodged an objection to the mistrial. So now you actually have the defense counsel. After the jury was dismissed, the defense said, I object. So actually there was an objection. Suggesting, but what was the basis of his objection? Suggesting that under GLC 234, section 34, the jury should have been told that they could continue deliberating if they wanted. So the defense's objection here was based on the fact that the jury should be told under this section, section 34, that if you want to continue deliberating, you are able to continue deliberating. That was the basis of the defendant's objection. Fuentes argues that despite the apparent deadlock, there was no manifest necessity for the mistrial because the judge neither asked the foreperson in open court whether there was any reasonable probability of unanimous verdicts, nor asked if the jury would consent to further deliberations. So now he argues, at the time it seemed that he just made an objection based on this section 34, 234, section 34, that the jury should have been told that they could deliberate further if they wanted. And now it seems like in the appeal, he's arguing more that there's no manifest necessity because the judge didn't ask the foreperson in open court whether there was any reasonable, listen to this, reasonable probability of unanimous verdicts or if they want to continue deliberating. So he felt that the judge should have asked the foreman, are there any do you have a reasonable probability of reaching a unanimous verdict or any of the verdicts? Now, this is what the court held. Nothing in our case law or in section 34 required the judge to make either inquiry as a matter of course, and the circumstances before the judge did not necessitate either inquiry. So here, the Commonwealth is arguing against the Karen Reed's motion to dismiss, that they are arguing that the judge should have explored the option of giving them going through the counts and allowing them to come to verdicts on maybe count 1, maybe count 3, maybe count 2. What are you hung on? Go through it, break it down like that. And here seems pretty clear that there is no requirement, nothing in our case law or in section 34 require the judge to make either inquiry. So you bet the Commonwealth quotes this case. They say, see, even what they're asking, even the alternative that they're asking that should have been done, this case says straight out that the judge is not required to make this inquiry at all. And the circumstances before the judge did not necessitate either inquiry. Fuentes also argues that he was not given an opportunity to be heard before the judge declared the mistrial. So hold on, I wasn't even given the opportunity to object before the judge ordered the mistrial. Just like in this case, the exact same thing in Karen Reed. I was not able to give any objection, not able to make any objection. So listen what the opinion. Listen to the opinion. Although, as the single justice stated, the more prudent course would have been to consult with counsel, the record does not show that such consultation would have produced any fruitful alternatives. So what is the case saying? What does this opinion stand for? The fact that even if you're not given the opportunity to object, so remember, this was the only argument that I can think of that the defense could use, that we were not given the opportunity even to object. This is exactly what happened in Fuentes versus Commonwealth. They were also not given the opportunity to object. So then you have to analyze it as, let's say we would have given you the opportunity to object. What were the alternatives that you were thinking of? You were thinking of the alternatives of either, right, the two options that he argued for was that is there, ask the foreman if there's a reasonable probability of unanimous verdicts, which sounds very, very similar to our case. See if there's any unanimous verdicts on the other charges, or ask if the jury would consent for further deliberations. So these are not fruitful alternatives. Nothing is required of the judge to offer these alternatives. And therefore, even if they would have objected, most likely the judge would have not given it. Certainly she was not required to give it. And therefore, this case stands very clearly in opposition to the defendant's position here, to Karen Reed's position. Now, there is also another issue, and that is not really a different issue, but an interesting issue that the Commonwealth makes out of here. And that is that even if you want to say that the judge should or could have asked for other for verdicts of count 1 and count 3 and asked them specifically, are you hung in count 1 and count 3? She could have made an inquiry into those areas. So there's a rule of criminal procedure about that. And this is, I think, where the Commonwealth a little bit mixes up in their motion, or they try to make the argument for it. Although really, I think that here they really made a little bit of a mistake in their understanding. But before, I just want to make one more comment on the Fuentes case. The Fuentes case was that they were asking, the attorney was asking, the defense attorney, was to ask the foreman if there was any reasonable probability of unanimous verdicts, which means that they would have to continue deliberating. That's what that means, right? Asking someone, is there a reasonable probability that you will reach a unanimous verdict? That was essentially the question, whether there was any reasonable probability of unanimous verdicts. That is really not asking the same thing as, do you have a verdict on count 1 and count 2 and count 3? Is there a unanimous verdict already reached? So that's possibly just one argument that the defense can make to kind of go up against Fuentes and say it's not exactly the same. It's not exactly the same as what happened in Karen Reed and Fuentes. Fuentes, all the attorney wanted to ask them if there's any reasonable probability that they may come to a unanimous verdict on any of the verdicts. But here, we would have been asking, are there any current verdicts that you do already agree on from count 1 and count 2 and count 3? Do you all have 12-0 on one of those? So that's maybe a little bit of an argument that a defense can distinguish and say that Fuentes is different than this specific case. But let's go back to the rules of criminal procedure. This is Rule 27B. And this is where it talks about taking verdicts on different charges. So this is what it says. If there are 2 or more offenses or defendants tried together, so if ignore defendants tried together, if there's 2 or more offenses, the jury may, with the consent of the judge at any time during deliberations, return or be required by the judge to return a verdict or verdicts with respect to the charges as to which a verdict has been reached. So this is specifically talking to this situation, that a judge is allowed, if there's different charges, to be asked to ask the jury if they can return with a verdict on any of the charges. And thereafter, the jury may, in the discretion of the judge, resume deliberation. Okay, so that is straight out of Rule 27B. However, let's not forget that there's also a lesser included. Okay, so it's going to get just a little bit, there's different charges, and then there can be one charge, and within that one charge, there's also lesser included. And the Commonwealth, in the response, quotes a case, Commonwealth versus Roth. Now, Commonwealth versus Roth was where a judge asked for partial verdicts, but that was only on the lesser included of a specific charge. So it wasn't like 3 different counts like we have in the Karen Reed case. It was in one specific charge where the judge asked them to come back with partial verdicts on that one specific charge of the lesser included. If you can follow that. Okay. But it's really simple. If there's 3 completely independent charges, so then there's no problem of taking partial verdicts. That's 27B. But the Commonwealth argues this case to apply to Karen Reed's situation where really it doesn't really apply. But they do use some language that shows that it can be very confusing and it's not going to get anywhere and you're just going to confuse the jury and things like that. That's how the Commonwealth represents this case of Commonwealth versus Roth. But really that has to do with lesser included and not 3 independent charges. So like in this case, 3 independent charges, there's really no problem at all under rules of criminal procedure in Massachusetts, sub 27B, to ask for separate verdicts. So she certainly could have done it if she wanted to, but the Commonwealth is claiming that it's not a good idea anyway. Now, there's one last part of the motion, of the response, which I alluded to a little bit when I was discussing the defendant's motion to dismiss, and that was the following. What type of conversation is an attorney allowed to have with a juror? If a juror was sitting on your trial and now you want to have a discussion with that juror, what type of discussion are you allowed to have? And the rules in Massachusetts are a little bit different than a lot of other jurisdictions, which is probably why Alan Jackson didn't think that there's anything wrong with talking to some of the jurors about what they wanted to tell him. The first thing is, as we spoke about, that in Massachusetts, the only way that you're allowed to, on your own, contact a juror is if you give the other opposing party notice. You have to send notice to the other party. If you want to contact the juror, you have to tell the prosecution, by the way, letting you know that I'm contacting this juror. Okay? But if the juror approaches you, then you don't need to give the other side notice. And in this case, Alan Jackson said in his affidavit that the attorneys the jurors contacted him. But still, there's some other problems. And that is what the substance of your conversations are allowed to be. And this is where the Commonwealth is arguing that Jackson actually may have violated some of these rules of professional responsibility. So here we go. Moreover, whether counsel initiates contact with the discharged juror by first sending notice to the opposing party with the substance of the proposed communication, or if the juror initiates contact with counsel as alleged in the defendant's motion, counsel may communicate with jurors only about permissible subjects. What are permissible subjects? See Massachusetts Rule of Professional Responsibility and Professional Conduct 3.5c. Permissible subjects include counsel's performance during the trial. So you can always ask, and this is the question we always ask the jury if we're able to speak to them afterwards. How do you think I did? Do you think I was too strong? Do you think I was too weak? Do you think I was, just give us on our performance. What do you think? How did you like my slides? You just always ask for their opinion about that. So permissible subjects include counsel's performance during the trial, extraneous influence on the jury's deliberations, like jury tampering, or a juror's bias towards a defendant. That's it. Neither extraneous influence nor a claim of juror bias is alleged by the defendant to have been an issue. In this case, that was not the issue here. That's not what they're arguing. They're arguing that the jurors told us that it was 12-0 on count 1 and count 3. So wait a second. Where does that fit in? What does that have to do with your performance? What does that have to do with the extraneous influence on the jury's deliberations? What does that have to do with jury bias? That's the only 3 categories, subjects that you're allowed to go into with the jurors. Rather, what the defendant's motion is entirely premised upon and what is expressly prohibited inquiry is that of the jury's deliberative process and the substance of the jury's deliberations. Excuse me. It is improper for counsel to inquire with jurors or through intermediaries, referring to Yannetti, the individual or collective thought process of the jury, the reasons for their decision, or the substance of their deliberations. And this is quoting straight out from the rules. Massachusetts continues to adhere to common law principles, barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry. Similarly, it would be improper for the court to inquire through affidavits or an evidentiary hearing the substance of a jury's deliberations. So you see from here, the Commonwealth is saying that we are not even allowed to have any sort of hearing about the substance of the deliberations, where the voting stood and why. The only areas you're allowed to talk about is, was there someone trying to manipulate the jury, or was there jury bias? That's it. And even that's all you're allowed to talk about. Did you have any bias? And finish. You're not even allowed to go into that too much. So that is another issue. So again, like I said, that all has to do with talking to the jury, bringing the jury back, trying to get them to give another verdict. That's not happening. Certainly not going to happen. The only area here is whether you can argue that the mistrial was inappropriate. We went through each step. It was not requested, but there certainly is a strong argument to say that it was consented to. And in fact, the Commonwealth pointed out that even after the jury was dismissed, and okay, the jury was dismissed, but potentially you can go ahead right away and make a record right there on the spot. And they were talking about scheduling, right? They're scheduling the next status conference. They're all there in the courtroom, and they're talking about scheduling. At that point, nobody made an objection. Nobody said, I object to that mistrial. So the Commonwealth pointed out, there you had an opportunity to object. Now, of course, the argument back will be like, yeah, well, it's already over. There's nothing to do at this point. You already dismissed the jury. But still, if you really felt that there needs to be an objection, you would have made it right then, and you didn't. So there's a very, very strong argument to say that there was consent here, because it's clear from the case law that not making an objection is consent. The only argument over here possibly is to say that they did not given any opportunity to object. And then we spoke about the Fuentes case, which seemed that even in that case, when there was no opportunity to object, but there was no reasonable alternative. So is that going to apply here? What's the reasonable alternative? So here, again, you're going to have to make the first argument. If you're the defense team, you got to make the first argument that it was not consent because we didn't have an opportunity to object. And this alternative to ask the jury if they do have specifically right now a verdict on count 1 and count 3, that would have been a reasonable alternative. And again, it doesn't seem like that there's any sort of requirement for a judge to do that. A judge may do that. So even if they can make that argument, the judge can say, well, I wouldn't have granted that anyway. So it doesn't matter. Just like Fuentes, it wouldn't have mattered if you made an objection. So I can say here also, I wouldn't have done that. And therefore, it doesn't matter that you didn't make an objection. So my call on this is guaranteed, almost guaranteed, that this motion is going to get denied. And even if it gets up on appeal, not such strong basis for appeal at this point to show that the fact that they didn't have an opportunity to object, because they did. And again, this argument, the Fuentes case really is strong against the defense. So, even if it goes up on appeal, this may not be the winning issue for Karen Reed. Well, that is it for now. Now you all understand what's going on in this motion and this response by the Commonwealth. Hope this was interesting and educational. If you haven't yet, please subscribe, like, and we will see you next time.